Hello, my name is Samuel Spatal, and I'm the Director of Litigation at the NAACP Legal Defense and Educational Fund. I appreciate all of you for being here today to tune in to our discussion from Shelby to Milligan, a decade-long fight to defend the Voting Rights Act of 1965. On Tuesday, June 25th, 2013, the Supreme Court issued its notorious decision in Shelby County versus Holder. In Shelby County, a sharply divided court essentially eviscerated Section 5 of the Voting Rights Act. And in so doing, the court removed a critical provision of the act that was proactive and prevented states and localities with particularly strong histories of discriminating against Black voters and other voters of color from continuing to do so. LDF litigated the Shelby decision and has worked with partners and plaintiffs across the Southeast and indeed across the country to seek to defend and expand Voting Rights Act. But then, just last week, almost exactly 10 years after Shelby, the Supreme Court issued a historic ruling in the other direction in the case of Allen versus Milligan. In Allen, the court upheld the other key provision of the Voting Rights Act, Section 2. The ruling affirmed a finding of a three-judge district court that Alabama's congressional map, which it first enacted in 2021, discriminated against Black voters by packing and cracking Black communities. While the decision in Allen does not undo the damage caused by Shelby County and the court's evisceration of Section 5, it does send a clear message to state and local lawmakers that Section 2 of the Act is intact and that under the law, states and localities must ensure that Black voters and other voters of color have a fair opportunity to participate in the electoral process. The Allen versus Milligan decision is one of the most important decisions in a generation. It's a historic victory for voters and for Black communities across the country, reaffirming this key protection established by Congress in the Voting Rights Act of 1965 during a time of countless attacks on the right to vote, many of those attacks having been unleashed by the court's own prior decision in Shelby. Today, we are joined by an all-star group of LDF litigators and leaders, past and present, who argued these cases at the Supreme Court and who continue to fight on behalf of Black voters nationwide. You will hear today from Janae Nelson, our current LDF President and Director Counsel, from Sherilyn Eiffel, LDF President and Director Counsel from 2013 to 2022. Sherilyn began her role as President and Director Counsel shortly before that Shelby County decision that you've heard a little bit about and you're going to hear a lot more about. From Debo Adegbile, former LDF Director of Litigation, who argued the Shelby County case and also argued a predecessor case to Shelby County, Northwest Austin Utility District versus Holder. And from Duell Ross, LDF's Deputy Director of Litigation, who just successfully argued the Allen versus Milligan case. So to begin, Sherilyn, if I could ask you, could you talk a little bit about situating Shelby County in the historical perspective of LDF's voting work?
Thank you so much, Sam, and I'm so thrilled to be with all of you today, and so thrilled that we're having this conversation after a win in the Milligan case. I think it's important for us to not stop talking about Shelby because Shelby literally changed the landscape of voter suppression in our lifetime, certainly our adult lifetimes. It was in its core a true rebuke of the real meaning of Section 5 of the Voting Rights Act and the intention of Congress in creating a regime that I think many people believe has been the most effective regime for countering racial discrimination in any civil rights statute. And that was the preclearance formula, which is, the only regime that exists in a civil rights statute that empowers us to cut off discrimination before it happens. And the regime that was created through preclearance, of course, required certain jurisdictions in the country that had a history of discrimination to submit any voting changes they wished to make, polling place changes, absentee ballot changes, voter purges, to submit those changes to a federal authority for approval before they could be enacted. And this allowed us to probe plans of jurisdictions, most of them, but not all of them in the South, to determine whether they would likely have an effect on the ability of Black voters to participate in the political process. And the federal authority, either the Attorney General or a federal district judge in DC, would either preclear the proposal, would ask for modifications, would ask for more information, or would deny it if the federal authority determined that, in fact, the voting change would negatively affect Black voting. This was the regime since 1965. And in the Shelby County case, the Supreme Court essentially gutted it and left us with the Voting Rights Act still available. There are many provisions in the Voting Rights Act. One of them we're going to talk more about today, which is Section 2. But it removed from us the ability to use Section 5, which had been so important and so powerful. And I think we all have seen what has happened in this country since Section 5 was essentially removed. And that is that since 2013, we have seen an explosion of voter suppression tactics around the country. So many of them that we have seen would not have been possible had Section 5 been in place, and they are ongoing. So the Supreme Court took away a vital tool that was very intentionally included in the Voting Rights Act and left us with Section 2, which is also a vital tool. It is less efficient. It is more expensive. It takes longer and can be more uncertain than Section 5, and that is Section 2, which allows us to challenge voting schemes that are in place that have been already adopted, and to challenge them on the grounds that they have the effect of diminishing the power of Black voting strength and an opportunity to elect candidates of choice. So those two pieces are the most important pieces of the Voting Rights Act. One has been essentially gutted and still remains for us to try and restore, but we need to do that through Congress. And the second is Section 2, which is the principal tool that we've been left with. And we had understandably been very concerned about the Supreme Court's approach to Section 2 because they have been weakening Section 2, most explicitly a year or two ago in a case called Brnovich. And so this case, the Milligan case, is such an important companion to Shelby because it once again presented the Supreme Court with a record that favorably supported, the position of civil rights plaintiffs because it raised an issue of vital importance, racial gerrymandering, because it essentially compelled this court to make a decision about whether they are willing to essentially snatch power from Congress and gut the core civil rights statute of the civil rights movement, the Voting Rights Act of 1965. And thankfully, as always, since 1940, LDF was ready, in place, prepared, long before redistricting happened, to ensure that we were ready to challenge any redistricting plan that was discriminatory. And ground zero, of course, is always Alabama. And there is no one who knows more about Alabama and voting than Duell Ross, who argued the Milligan case.
Thank you very much, Sherilyn. So Sherilyn has really given us an arc of LDF's work in voting and the significance of Shelby and what we've seen since. Debo, if I could turn to you and ask you to reflect a little bit on your experience litigating Shelby and seeking to defend Section 5, both in the Shelby case and the previous Northwest Austin case. What was the kind of evidence that LDF sought to present to the court and which LDF thought was so compelling and unfortunately the court sort of refused to fully consider?
Thanks, Sam. And as you said, Sherilyn really framed it very well. When we think about the case and the record in that case, the evidence that we were trying to put before the court was really just amplifying what Congress found. Congress assembled what was regarded as an unprecedented record in support of the extension of the Voting Rights Act in 2006. And in the Shelby County case and the predecessor case, we were really pointing to the court, asking the court to take account of the findings and the careful deliberation of Congress. And essentially the big frame of what Congress found is that there were two truths that animated the sweep of the Voting Rights Act from passage until the time of the 2006 reauthorization. One truth was that a great deal had changed. There was progress, demonstrable progress. Congress reflected that in the record, and Congress made the point that that progress was because of, not in spite of, the Voting Rights Act. The progress in opening the democracy, in expanding representation, in creating opportunities for minority communities to elect candidates if they're choosing to represent them. That was all part of the story of the Voting Rights Act, which had been regarded and which the Chief Justice acknowledged in Milligan as one of the most important pieces of civil rights legislation ever passed. And so Congress took cognizance of that progress, and we did too in the litigation and certainly in the congressional record. But the other side of that was that a great deal hadn't changed, and that many of the mechanisms, many of the approaches, many of the tactics of trying to undermine the voting power of minority communities continued. And we saw that because of all of the discriminatory measures that were blocked, as Sherilyn said, by the preclearance provision of the Voting Rights Act, the things that were stopped before they could take effect, but that nevertheless governmental entities were trying to put in place to weaken and worsen the position of minority voters in the electoral process. Sometimes it was small things like moving around polling places on the eve of election. And sometimes it was big things like redistricting plans that would apply statewide and would diminish the voice of minority communities and everything in between. And we showed that both of those things were happening, that we had come away because of the Voting Rights Act, but that the work was unfinished. And so what we asked the court to do in Shelby County was not to begin anew, was not to find evidence in the first instance, but was to do two things. One was to follow its own precedents, which consistently had recognized that the preclearance provision was a vital civil rights protection that was within Congress's power to enact. And then second was to defer to the constitutionally given role of Congress to make laws that should enforce the 15th Amendment to the United States Constitution. The 15th Amendment expressly gives that role to Congress to make those laws. And having done a very detailed inquiry over 16,000 pages of congressional record, making out the proof that I've just described, essentially what we were asking the court to do was to do no harm and follow the weight of evidence that was before it, and also to follow the weight of precedent. And so in many ways, our case should have been a very easy case in the Supreme Court. It's rare that you get to stand in the podium and argue that the court should follow four of its own precedents, finding in your way. And that's in part what made the Shelby County ruling so remarkable, that it was a break, a dramatic break with more than 40 years of precedent that had upheld the constitutionality of the preclearance provision of the Voting Rights Act.
Thank you, Devo. If I could turn to you, Janae, and ask you, I guess, two related questions. What sorts of voter suppression laws did we see after Shelby that were at least in part attributable to the court's decision? And then the flip side is, what was left for civil rights attorneys and the civil rights community more broadly after Shelby? What were ways in which the court allowed folks to continue to seek to vindicate voting rights?
Yeah, that's an excellent question, Sam. It is really impossible to measure the colossal fallout in terms of the damage to our democracy and the threats to the right to vote as a result of the Shelby County decision. You've heard Sherilyn and Davo talk about some of the specific ways in which people were denied the right to vote or voting was made more difficult. You know, by way of example, in the first 5 years following the ruling, nearly 1,000 polling places were closed, and a disproportionate number of those that were closed are in predominantly Black counties, and that made voter turnout much more difficult to achieve. People often get confused when you hear about robust Black voter turnout, but that is in spite of the very real obstacles that are now imposed as a result of the preclearance measure being taken away. Other fallout includes cuts to early voting, new and strict voter ID laws, which is something that LDF has also fought against in a number of cases, including the Veazey versus Abbott case. And we also saw a proliferation of purges to voters from voting rolls across the country. We saw voters literally being taken off of the rolls and having to re-register, or finding out the day of an election that they were no longer eligible to vote because they had been removed. And this happened to Black communities disproportionately, as well as Latino communities. And then if you fast forward to the 2020 elections, right after the January 6th insurrection, states across the country began introducing legislation that was effectively extreme voter suppression law. And it diminished the ability for voters to really express their voice at the polling sites across this country. The 2020 election season was rife with voter suppression bills. And following that, we saw in 49 states baseless legislation being introduced on the theory that there was some conspiracy of election fraud. There was some reason to doubt the security of our election system. All of those were based on mis and disinformation, and all of those were enabled by the fact that there was no filter for any of these new voting laws, because Shelby County removed the ability of Section 5 to operate to protect our democracy. So there was a dramatic increase in attempts to suppress the vote in Black and Brown communities. And since January of 2021, 49 states have introduced hundreds of bills restricting the right to vote. 32 states have passed more than 85 voter suppression laws. And one of the other dimensions of this that people don't often recognize is that this has increased the cost of participating in our election, figuratively and literally. Organizations like the Legal Defense Fund have to operate an election protection apparatus every election to help protect the right to vote. We have to be on the ground to make sure that people have access to the polls. We have to send out education materials well in advance of elections so that people aren't confused by these new voter suppression laws. And there's much more that needs to be done to get the turnout to be what it should be. And it is never enough, because there are still more obstacles placed in front of Black voters in particular to deny them the right to vote, even with these significant investments in the voting process. So the fallout from Shelby County is still quite devastating. As we've been saying for a long time, our democracy is on a razor's edge, and a lot of that is due to the Shelby County decision. Now, you asked about whether there's sort of a flip side. Is there some hope for what might be resurrected from this Shelby County decision? And I think it's important to note that the decision did not rule out the ability to resurrect Section 5. It actually it basically put on hold the ability to use Section 5 by saying that the trigger for preclearance was outdated. And Chief Justice Roberts, in his majority decision, expressly invited Congress to update the triggering provision for Section 5, and Congress has failed to do so. So there are many opportunities for us to right the wrong of Shelby County if we are able to elect a Congress that has the courage and conviction to protect the right to vote by enacting the John R. Lewis Voting Rights Advancement Act that will update the formula and allow Section 5 to continue to protect our democracy as it had done for decades, and to limit the exposure that Black and Brown voters in particular face in light of Section 5's suspension.
Thank you, Janae. Joelle, if I could turn to you. We heard from Janae in really sobering detail about the impact of Shelby and just the magnitude of the voter suppression that was unleashed as a result of that decision. What aspects of the Voting Rights Act or other laws have civil rights organizations like LDF used in the years since Shelby to try to push back at that suppression? And how do those efforts tie into the most recent decision that we're so excited about in Allen?
Thank you. So as everyone has been saying, really what we've been left with the demise of preclearance and the Section 5 regime is a handful of tools, particularly Section 2 of the Voting Rights Act. As Sherilyn mentioned, Section 2, unlike Section 5, allows you to challenge discriminatory laws after they've already been passed. And so rather than the prior preclearance regime in which a state would pass a law and then have to seek permission from the federal government, now what happens is that the state will pass a law and plaintiffs have to go into court and prove that that law is racially discriminatory. And until plaintiffs can win before the courts, that law stays in effect. And so I think a really a dramatic example of this is what happened in Texas. Texas passed a racially discriminatory voter photo identification law. It was essentially undisputed that the law would make it difficult for hundreds of thousands of Texans who are disproportionately Black and Latino to vote. And in a 3-judge court before Shelby County had actually blocked the law, finding that it was racially discriminatory and that Texas could not implement it. But the day that the Shelby County decision came down, Texas went ahead and said that they were going to enforce the law despite that prior ruling. A number of plaintiffs groups sued to challenge Texas's discriminatory law. And although they were ultimately successful, it took over 3 years of litigation for that law to finally be blocked, and multiple trips to both the Supreme Court and the Fifth Circuit Court of Appeals. And in fact, the entire Fifth Circuit Court of Appeals had to hear the case before the law was finally blocked and found discriminatory. And so I highlight this to say 2 things. One is that Section 2 remains a really vital tool. That's obviously what happened in the Allen versus Milligan case is what Chief Justice Roberts recognizes, that Section 2 remains viable and that it's a means by which Black and other voters of color can defend their rights, even in the absence of the even more powerful and important tool of Section 5. And 2, that, even the most meritorious cases under Section 2 are not, able to get relief as quickly and as fundamentally as Section 5 was. And so it really emphasizes the importance of the continuing need for Congress to act to restore Section 5 of the Voting Rights Act, and also for local governments to pass their own versions of the Voting Rights Act. The other tools that I think are available are, various other provisions of the Voting Rights Act, which have been used with similar success to Section 2. Some successes, some not so complete successes. So, really what's important here is the need to restore Section 5 of the Voting Rights Act.
Thank you very much, Duell. And on your point about sort of these other tools, I will just note that LDF has active litigation under Section 2 in multiple states, challenging both discriminatory redistricting and these voter suppression laws that we've heard about. And those cases do involve the challenges that you were just talking about, Duell, because Section 2 is not able to block discrimination before it happens, but that it is also remaining very important that LDF and other civil rights organizations are able to push back in those ways. So if we could shift gears a little bit, I'm interested to hear from both Debo and Duell. You've litigated these cases, you've argued on behalf of Black voters in the United States Supreme Court, but this work begins in a very different way. It begins with our clients, it begins with folks who are seeking to vindicate their rights in their communities. And ultimately, it's the stories of our clients and the plaintiffs that are the ones that the court is considering. I'm wondering if you could share a little bit about those stories, about why this work is so important to the people that we're representing and on whose behalf we're advocating. Maybe if we could start with you, Debo, and then turn to you, Duel.
Great. Thanks, Sam. And thanks for the focus on that important point. I think sometimes that story can get lost, but at LDF, it never gets lost. That's why LDF exists. And that's why we bring these cases through the decades. That's what the equality principle is about. It's creating opportunity for people to have the full measure of citizenship in our country and of their constitutional rights. So it was actually an extraordinary opportunity to represent a group of interveners out of Shelby County. One of the stories that animated the case that we took to the court was in fact the story of an elected official who was the choice of Black voters in Shelby County, but through the type of sleight of hand that we see in the political process and through various discriminatory measures, his seat was taken away through various redistricting approaches in Shelby County. And so there was an effort to sort of take away the voice that Black voters had received in the district. And so in litigating the case, we told the story of how these districts were manipulated, how how the clock had been turned back, and how it was only the Voting Rights Act that helped restore and put in place some of the opportunities for Black voters living in Shelby County to actually pick the elected officials whom they wanted to have representing them. And the story of Ernest Montgomery and of his colleagues in Alabama was an important one that we were telling to the court. And I think it was that story and the way in which we told the story to express what was happening, not in ancient times, not in 1965, not in the 1970s, but contemporary stories about how discrimination was presenting itself in Shelby County, the jurisdiction that decided to bring the constitutional challenge to the Supreme Court. I think that's what led Justice Sotomayor to begin her questioning of our adversary by asking why Shelby County came before the court. Shelby County is the example of why we need the preclearance provision of the Voting Rights Act. That was essentially the thrust of her question. And so representing individuals, lifting up their stories, it's not just something that is done for a benevolent reason. It actually is what the cases are about. And if you do it well, as LDF has done it well over so many decades, you're able to animate the stakes and illustrate and crystallize what are the equality principles that are at stake. And that's what we try and put before the court in case after case. And I think it's fair to say that's what Duell did so brilliantly, as one reporter has called it masterfully in his presentation in the Milligan case.
Thank you, Debo. What about for you, Duell?
I think one of the things that probably made the difference, both makes a difference in the way LDF presents the case and also made a difference in the Supreme Court, is the fact that we were really client-centered. Our clients came to the argument. Our clients testified at trial powerfully about the importance of representation to their community. And that came through in Chief Justice Roberts' opinion. He talked about the region of Alabama called the Black Belt. As Chief Justice Roberts described it, it contains a high portion of Black voters who share a rural geography, concentrated poverty, unequal access to healthcare and government services, and lineal connection to the many enslaved people brought there in the antebellum period. This region of Alabama, as the three judges in the trial court found, is in some ways more akin to the developing world than it is to the rest of the United States. But it's also a place that has a really rich and important history, both for the US and for African Americans, for the South. It's the place where Martin Luther King began his ministry. It's the place where the Montgomery bus boycott began. It's the place where the march from Selma to Montgomery that sparked the need for the Voting Rights Act and Congress's action to pass the Voting Rights Act initially in 1965 began. All of these important historical markers occurred in the Black Belt. And that was a part of the story, talking about the fact that Alabama has chosen to split this Black community into 4 different congressional districts for the last 50 years, just as Black people were securing the rights that they had won after the Selma to Montgomery March on Bloody Sunday. And yet Alabama, sort of with a not so straight face, went to the court and said that this Black community wasn't entitled to representation, or at least not the same representation that Alabama was trying to give to a particular white community in the Gulf Coast. And so, being able to tell the stories of our clients, like Evan Milligan, who was in Berlin learning about the Holocaust at a church where Dr. King had actually preached when he found out about the decision, and has, as he describes it, cried tears of joy, thinking about how his father and his own family's name would be associated with not with another blow to the Voting Rights Act, but with the Supreme Court robustly defending it and upholding the constitutionality of Section 2 of the Voting Rights Act. Our clients like Shalala Dowdy, who is an amazing young woman who has been very active in her community of Mobile, Alabama. They testified at trial. They've been very public about the need for representation for African Americans. And I think that is what made the difference, both at the Supreme Court and in all of LDF's advocacy for on behalf of Black voters. It's our ability and our commitment to centering the work and the experiences of Black people and our clients.
Thank you, Duell. If I could just note one thing that for me really resonates with what you both said. At LDF, we often think about the way that we are building upon the work of those who came before us. And I think there are these 2 lines in Shelby and in Milligan from Chief Justice Roberts, the author of both opinions, where the language is almost identical. In both cases, he says, history did not stop in 1960 or 1965, but he's using that in the opposite way. So in Shelby County, he's using that as a justification for saying, well, I'm going to eviscerate Section 5 because history didn't stop in 1965, and a lot of the civil rights violations that folks are talking about from the 60s, from his perspective, were not present anymore. But I think it's because of the way that LDF attorneys told, both in Shelby County to sort of plant the seed and then continued so powerfully in Milligan, told the stories of our clients, because our clients did have the courage to be there, to stand up, to speak the truth about what was happening in both cases. You see the shift where in the most recent case, Chief Justice Roberts is saying history did not stop, but that does not mean that discrimination is over. In fact, it means that in some ways, states and localities are discriminated in new ways, which shows why a law like Section 2 continues to be important and why it continues to be and needs to be interpreted robustly. So I think that is, a result of the fact that our clients are so amazing and so courageous in having their stories told, and to both of you for the advocacy that you did in presenting that to the court. So to shift gears back to you, Janae, you and Duell both have talked about the fact that there's a role for Congress. There's also, Duell talked about a role for state legislatures. Can you talk a little bit more specifically about what you think Congress should be doing to restore Voting Rights Act protections more generally, and also what state legislatures can do?
Absolutely. But I do want to just double down on what both Debo and Duell have said about the importance of centering the stories of our clients and humanizing what is often characterized as a political issue. This is not about politics. This is about the right to vote in a democracy. This is about American citizens being denied a critical way to express themselves and impact the representation in this country, which is really at the foundation of what this country is about. So I just want to thank them for their incredible advocacy. And you are right to point out that it builds over time. And I firmly believe that in rejecting the powerful case that Debo put on in the Shelby County decision, Chief Justice Roberts saw the decade that followed and saw the fallout from that decision and saw the active discrimination happening in Alabama and had to rethink his positioning on this issue of voting rights discrimination in this country, maybe not entirely, but at least in this egregious case. And that's due largely to the powerful advocacy of these two formidable SCOTUS advocates. So I just had to make sure that we underscored that point again. We are actually presented with a very, very exciting opportunity that sadly comes out of the injustices visited upon Black communities, as often our evolution of our democracy does, right? It's rooted often in the oppression of Black voters that reveal the fissures in our democracy and the frailties of it. And we have an invitation, as I said earlier, to correct the wrong of Shelby by enacting the John R. Lewis Voting Rights Advancement Act. And in lieu of having a Congress that will enact this national federal legislation to resurrect Section 5, but also to correct many of the imbalances and unfairness in our democratic processes, we can advocate on the state level. And we have been doing so successfully by passing state voting rights acts. Just recently, the state of Connecticut joined the first 5 states that enacted the John R. Lewis State Voting Rights Acts, and they vary depending on the state that you're in terms of certain provisions, but they create an example of what a fair democracy can look like state by state. And many talk about the fact that the states that have enacted these voting rights acts are states where, yes, there has been racial discrimination in voting, but perhaps not the most egregious examples of it that we've seen. But I do believe that by setting this example, by having these laboratories of democracy across the country, we are creating examples of what a high-functioning democracy with adequate protections can look like. And voters in other states will begin to see the competitive disadvantage that they are at by not having greater access to the ballot, by not having some of the interventions that these state voting rights acts provide to protect the right to vote, and that really build on the legacy of our iconic Congressman John Lewis and the many foot soldiers and others who sacrificed to advance our democracy and ensure that we have the freedom to vote and the freedom to influence our representation across the country. So, quite simply, the John R. Lewis Voting Rights Act would resurrect preclearance. It would stop these discriminatory voting changes from taking effect while they're reviewed by either the state government or ultimately, if we get it passed on the federal level, by the Department of Justice or a federal court. And it also includes important provisions to protect Native American tribal lands and creating equal access to voter registration and polling places and early voting locations and mail-in ballots, all of the things that really should be no-brainer features of a modern democracy. So we are pushing for the passage of federal legislation, the John R. Lewis Voting Rights Advancement Act, but also moving state by state to push state legislatures to do the right thing by their residents and increasing access to the ballot. I should also say that the John R. Lewis Voting Rights Advancement Act is complemented by another piece of federal legislation that is also crucial, and that is the Freedom to Vote Act. And the Freedom to Vote Act does other things to help reduce the influence of big money in our politics. It requires important disclosures of donors. That's helpful to create more transparency in our elections. It also eliminates some of the partisan gerrymandering that we see as now a regular feature of our redistricting processes that cement an imbalance of power. So there are many ways in which we have an opportunity in this moment where there's greater focus on the problems in our electoral process to enact federal legislation and push Congress to do so, and short of that, to continue the robust advocacy at the state level.
Great. Thank you, Janae. Cheryl and Janae was talking about John Lewis, about other sort of history makers when it comes to our democracy. And same, we've heard about Evan Milligan and our amazing clients who have truly made history by having their cases considered at the Supreme Court. What can anyone listening to this webinar do to have their voice heard, to play a role in moving us towards a more inclusive and just democracy?
That's a great question, Sam, because we are not bystanders in this process of our democracy, and each of us have a role to play. And I want to be sure that I emphasize again the important role that LDF and other civil rights litigating organizations are playing and have played. You all well know that Thurgood Marshall, when asked about his most important case, did not say Brown versus Board of Education, which we might have expected, but referred to Smith versus Allwright, the case he won in the United States Supreme Court in 1944, which ended the all-white Democratic primaries in the South, or at least was the beginning of the end of the all-white Democratic primaries. And he said it was because he believed that Black people being able to amass political power would enable us to be able to control our destiny. And so that arc does not begin with Shelby. It begins much earlier for the kind of work that LDF has been doing. And I think one of the things that was critical in this argument that Duell had in the Milligan case that we really shouldn't skip over is the role of Justice Jackson, the first Black woman Supreme Court justice, and her colloquy with the lawyer for Alabama about the meaning of the 14th and 15th Amendment, about race consciousness, about what Congress wanted and expected for Black people after the end of the Civil War. And I think actually that little history lesson, if you have an opportunity to listen to the argument that Justice Jackson laid out, and no doubt the history lessons that she was laying out behind closed doors that we will not see, because she has demonstrated her willingness to really deal with the history and to look at the original documents and to really reset what the conversation is about the 14th and 15th Amendment and about race consciousness and where it is permissible. But to go more directly to your question, Sam, about what every person can do, it is true that every person can register and vote, and that is, certainly the most important. But you also know that I believe we are selling ourselves short. My mantra has been leave no power on the table. And so that means not only voting, but voting robustly in every election. There's a lot of conversation right now about 2024, the presidential election and Congress, but there are elections this year in your state, I can assure you. And so making sure that you pay attention to the sheriff elections and the school board elections. One of the things that was so difficult about losing Section 5 is that, as has already been described, litigation takes long. So yes, we successfully challenged the voter ID law passed in Texas after the Shelby County decision, but it took years to finally vindicate those rights. And in the meantime, in Texas, there were hundreds of state reps in both the House and the Senate who were elected. All of the DAs in the state were subject to election, all of the sheriffs in the state, all under discriminatory voter ID law because it couldn't be vindicated until the case was completed. So we need that strike force action, and that goes to Janae's point about federal legislation. You need to be calling your congresspersons, your House members, and your senators and telling them that you expect that to be on the agenda. You need to be voting in these elections for sheriff and school board. And then you need to double down on your vote by actually showing up to hold your representatives accountable, raising these issues with them at town halls, showing up at city council meetings, ensuring that your representatives know that you are watching them, that you are there in the county commission meeting, that you are making your voice heard. Think about what's happening in school boards across the country and the way in which our history is being erased by school boards determined to not allow our children to learn the truth about our history and contributions to this country. How many of you have voted in school board elections? How many of you have attended a school board meeting? How many of you have run for school board? I think it's time for us to be all in on our democracy. And that means up and down the ballot. That means for every office. That means showing up. And it also means not giving up hope. Earlier, you talked about, the pieces of the Voting Rights Act that are still available to us. And we talked about Section 2. But as you all know, there are many others, and LDF is using them. We have a right to not only cast our ballot, we have a right not only to be represented in our maps, but we also have the right to make sure that our ballots are counted and added to the total. And as we all know from 2020, the new front is threatening election workers and trying to steal votes after the election happens. And there are provisions in the Voting Rights Act that allow us to address that as well. So LDF is using the full Voting Rights Act and all the elements that remain available to us for litigation. But we need every single person to use all the tools available to them, to you as a voter and as a citizen, to make sure that your voice is heard, to not give up hope, to continue to participate in the political process, to share information. Go to LDF's website, which always has a treasure trove of information about voting, and stay woke.
Thank you, Sherilyn. That is a perfect segue to the final question that I wanted to ask all of you. I believe we have about 5 minutes left, so if you could all take about a minute to address this question, which is, this is a difficult and dangerous, really, time for our democracy in many ways, as you've just described, Sherilyn. Especially with that as the background, what does give you hope for the next chapter of voting rights advocacy, or for the next chapter of our democracy more generally? And maybe if I could start with you again, Sherilyn.
Those of us who do this work, who do civil rights, particularly legal work, litigation, understand that this is a process that requires determination, patience, and resilience. And I think the win last week in Milligan is such a powerful example of that. If you stay in this work long enough, you will see those changes that you described, Sam, in which Chief Justice Roberts painted a rosy picture about what is happening in the South in the Shelby case, and had to take some steps back to address the issues raised in the Milligan case. We have to be able to have the kind of resilience and the kind of patience and the kind of determination to be able to continue to push that rock. For some people, it doesn't go fast enough. For me, it doesn't go fast enough. For none of us, it goes fast enough. But there have to be some of us who are willing to be patient. I know lots of people said, this decision was a small thing in light of all of the things that the court has done. It remains to be seen what the court will do. We are in dangerous times. I think the willingness of Justice Barrett to join the dissenters in the Milligan case is quite ominous. But I also think that having seen what Justice Roberts did and Justice Kavanaugh in this case, seeing the effect of Justice Jackson in the conference, and continuing the kind of powerful litigation that so many LDF lawyers, and most recently Duell and Team Milligan presented, gives me hope that we have the resilience, the patience, the power, the determination, and the excellence to prevail.
Thank you, Sherilyn. How about you, David? What gives you hope?
So I'm thinking about the arc from Shelby to Milligan. I'm thinking about how hard we fought to try and show the court that it would be disastrous to take away the protections of the preclearance provision of the Voting Rights Act. And I'm thinking about LDF and Duell's defense in Milligan. One of the cornerstones of the argument that the petitioners were making in the Shelby County case is that we didn't need the provision that was focused on some of the places where discrimination had been the worst, because we had a nationwide provision. And what we've seen since, and what my colleagues have been referring to, are other cases decided under Section 2 where the court seemed prepared to try and cut that back, strip away the protection that they were relying upon, in part to establish the rationale for the Shelby County ruling. And so what gives me hope is that at least we have had a pause. When I look at the Shelby County decision and I speak about it, I speak about the harms that Sherilyn described, taking away what we sometimes call the heart of the Voting Rights Act, one of the most effective civil rights statutes in the history of our country, taking that away and making it inoperable. That's an obvious and immediate harm. But what was as scary to me and as ominous was that it sent a signaling effect in this country that the Supreme Court was in retreat on the principle of protecting minority voters and keeping our democracy available to everybody. That is the signal that was received after Shelby County, and that is consistent with the actions that we have seen across the country, an escalation of discriminatory voting conduct. And so now, perhaps with some recognition of the path that we've been on, perhaps with some recognition of all that we have seen in the last 10 years, the court, at least in this moment, is recognizing that wiping away almost 40 years of precedent, disregarding express congressional reauthorizations and amendments to statutes intentionally done, that is a risk that the Supreme Court should not be engaged in, and a majority of the justices stood for that proposition. Last point here is that I think that Milligan itself is an example of why we need Section 5. The idea is that had the preclearance provision been in effect, the election that happened under a redistricting plan that now two Trump appointed judges have said it's not a hard call that the plan was discriminatory. That's what they said in their ruling. And now the Roberts Court has decided that there is a likelihood of success on the merits. But nevertheless, that is the plan under which elections happen, because we don't have preclearance to stop it before we can take effect. So Milligan is an important victory. It also is Exhibit A on why we need to restore the preclearance provision of the Voting Rights Act.
Thank you, Debo. What about for you, Dual? Having just led the team that was successful in the Supreme Court of Milligan, what gives you continued hope?
What gives me hope, and what's always given me hope, is my colleagues, both Sherilyn, Janae, Debo, you, Sam, and everyone else who is working on this, and the clients. The fact that people who live in places in which the state and local government is actively trying to disenfranchise Black voters, is actively disregarding access to federal funds for things like public health care or education, but that they're still fighting for a world in which their rights are respected, in which they can drink clean water, in which they can go to schools that are fully funded. All of that, seeing their resilience in the face of an unrelenting history of discrimination that dates back at least 400 years to African Americans being brought to this country, is what gives me hope that their change does not and will not come fast enough. But the fact that people continue to fight and have always continued to fight for a world in which they can't see, as Sherilyn often says, is what continues to give me hope and what keeps me going.
Thank you, Dual. How about for you, Janae? What gives you hope, and any other sort of closing thoughts that you have?
Yeah, I've been saying that Milligan has delivered us a once-in-a-generation opportunity to seize the promise of our democracy and advance it in a way that we have not seen in decades. We have an opportunity to use this win, and it is an unequivocal win, to quote Mr. Ross, to use this win to galvanize communities across this country who have been shut out of the political process, to elect candidates of their choice who presumably would help pass legislation that will allow our democracy to function fairly, to give their voice amplification, and to right what has been a severe attack on our democracy at its core. I am very hopeful that through this case and others, through the advocacy of organizations like the Legal Defense Fund and our co-counsel in the Milligan case, the ACLU and the ACLU of Alabama, and so many other organizations that have brought attention to the attack on our democracy, that there's a whole new generation of young people who've been energized and who are agitated by the obstacles that they see to participation in our democratic processes. And I am relying on us and them to move the dial in a very transformative way in this moment of turmoil and upheaval. We have a choice as to which path we want our democracy to take. And we now, thanks to the Milligan case and the work that the Shelby County case did, the advocacy to provide this fertile ground, we have an opportunity to elect a Congress that can do what is necessary to allow all communities to cast a ballot that will be counted, to engage in this representative democracy in the way that we never have been able to before. So I feel very hopeful. I'm very clear-eyed about the obstacles that remain, and that while this case is a win, it does not signal a 180 about face on the Supreme Court on all issues pertaining to racial discrimination by any means, and that we will have to continue to fight, and that the fight in Milligan is far from over, as is the fight in the other cases that LDF is litigating in Louisiana and in South Carolina and Arkansas and in so many places across the country. But we now have an opportunity to do what a week ago would have been impossible to think of, and that is to recalibrate our Congress and our representation to enact the John R. Lewis Voting Rights Advancement Act, to enact the Freedom to Vote Act as we approach the 2024 elections, and engage, as Sherilyn directed, at every level and every election in between. That is our mandate, and that is what keeps me hopeful and confident that we have a new horizon to reach.
Thank you, Janae, and thank you to all of our panelists for what, from my perspective, was an engaging, energetic, and really inspirational conversation at what is an inflection moment in our democracy. Thank you to everyone who joined the conversation to listen. If you want to learn more about LDF's voting rights work or the organization generally and how you can get involved, please visit our website, www.naacpldf.org, or follow us on social media. Thank you.